I am back. I was in beautiful Clearwater, Florida for the past 10 days visiting family. What a lovely place, the Sugar Sands. Voted the #1 beach in all of the US, and apparently Tom Cruise has moved there now. I was trying to stalk him at Publix, see if I can catch him buying groceries, but I couldn't. So we'll have to try again next time I go, see if I can get him into the cult of Star Citizen, which is a superior cult, as we all know. Lots to catch up on as I'm getting back into the groove. The whole Crytek vs. CIG story back in the news again. We're going to take a look at that. Let's jump right in. Ladies and gentlemen, I am Montoya. More Crytek vs. CIG news. It's been a while since I took a look at this. To recap, there was a whole bunch of stuff which which Crytek took, and they threw it up in the wall. They threw it in the wall to see what's going to stick. And what's happened is CIG, this is back in January, the last time I made a video about this, CIG said, no, we want to dismiss everything. Now, YouTube lawyers Leonard French and Leo Lesser said, no, highly unlikely that a judge would dismiss anything. And what happened was the judge walked up to the wall, saw the stuff sticking and said, you know what, this is garbage, that's not going to stick. This maybe, this is nonsense, maybe that too. So what we have now is a list of 6 items of a motion to dismiss, some denied, some granted. And we'll take a quick look at that. I also want to give you the link to Leo Lesser's video. He is the YouTube tech lawyer. He explained things in a lot more depth than I could because we are just armchair lawyers who are trying to wing it. But he had some pretty good advice and insights into what was said. So I'm going to link his video down below. Give that a look when I'm done here, obviously. But for now, let's take a look at number 1 through number 6, what the judge has to say. First of all, before we jump into it, the Star Citizen unhinged haters. They're dancing around going, oh, this is the end of CIG, finally. No, listen, no, that's not the end. If anything, any possible damages to CIG are limited, and we'll get that, I think it's point number 4 or 5. But yeah, this is not the end of CIG. If anything, this is moving a lot closer. And look, Crytek needs their day in court. Let this happen. Let the law work as it should. Let's take a look. Number 1, motion to dismiss denied. As far as kicking everything out, no. Judges, no. There's something I want to look at. Number 2, motion to dismiss is granted as far as the exclusive embed of CryEngine in the game. This is one of the things which were nonsense, if you remember. At no point was CIG locked into using CryEngine. If you get a game engine and you're trying to make a game and you hit a wall where that engine cannot do what you need to do, you are free to move to another engine. This is what Leo Lesser was saying, a YouTube lawyer. And the judge agrees. Go, listen, the term exclusive is not what Crytek tried to pitch it to be. I mean, they gave it a shot. Judge says, nope, I don't agree. So in favor of CIG, they are by no means locked into using CryEngine. Number 3, motion to dismiss denied insofar as CryEngine being unauthorized used in Squadron 42. This was an interesting one, which I thought would be a home run, but it wasn't. Now, what happened in the very first paragraph of the GLA, if you remember, it says, CIG is licensing this CryEngine for Squadron 42 and Star Citizen. These 2 things are the game. It's written there very, very clearly. Crytek says no. Now, the judge is probably wondering, why would Crytek say that? Even though it's spelled out very clearly, it seems the judge simply wants Crytek to explain further. What CIG is going to say, CIG is going to tell you that Star Citizen and Squadron 42 are indeed the same game. One is just a single player, one is just the MMO part. These are not 2 separate games. If CIG made a game called Farming Simulator 3000, which had nothing to do with Star Citizen, I would say absolutely Crytek is right. But Squadron 42 uses the same assets. It's everything that's in the MMO part. It's a single player part, which you should play first, which then opens up into the MMO. The closest analogy I can think of is possibly Rockstar's GTA 5, where you have story mode and there's online mode. Now, would you say that online mode GTA is a separate game from story mode? I would say no. More so for Star Citizen because the character you make in Squadron 42 is the exact character that will carry you forward into the MMO part. Plus, it's all going to launch from the same launcher. This is what CIG is going to explain in court. And under these descriptions, I think very much so the judge would agree that this is indeed covered by the license as stipulated in the GLA. The judge just wants to give Crytek the opportunity to argue their side. Fair enough. Number 4, motion to dismiss denied in respect to plaintiff's cause of action copyright infringement. Now, this had to do with essentially the Crytek logo being removed and also possibly CIG sharing source code with a third party or revealing source code on the Bug Smasher videos. The Bug Smasher video part, I don't know. Okay, I'm not an expert on this, but what we saw in Bug Smashers, what we see in Bug Smashers, is the markup language. Markup language is not the source code. The same way that I can go to any website, cut and paste the HTML, it's not going to give me a working website because the actual code lies in the back end of that, not in the markup language part. But this is something which I guess they're going to discuss in court. Now, did CIG share some code with, say, Faceware? I would be surprised, but listen, if Ortwin, who wrote the contract and is a co-founder, allowed this to happen under his watch, then CIG definitely owes Crytek something. This is why laws exist. And again, this will have to be their day in court. It all comes down to when the switch happened from Crytek to Lumberyard from CryEngine. I suspect CIG probably covered the bases well in this, but if they didn't, then yes, they owe Crytek something. And this comes down to number 5, motion to dismiss. Prayers for relief denied respect to monetary damages, granted in respect to punitive damages. What this means is that Crytek cannot sue CryEngine, Crytek, I get those mixed up, cannot sue CIG for a made-up number of $500 million. What it says here is, if you did make a separate game like Squadron 42, then you owe us what a game license would have cost for that. They can't sue for some magical huge number to make up. That is what that's about. Number 6, nothing too fancy, but with that, let me give you the link to Leo Less's video, which is posted below. Watch what he has to say. It's pretty good. And with that, let's wrap this up. Good to be home again. Don't forget to thumbs up and subscribe. I'm over 9,000 subscribers. By the way, do I have to do the traditional over 9,000 video? We'll see. Once again, thanks for watching. Don't forget to subscribe. I'll see you in the next one.